Okay, so let's get going. In this lecture podcast, I'm going to be talking about the executive power in the Australian Commonwealth, and I'll also talk about responsible government and collective responsibility of the ministers and the cabinet. So I've had the opportunity to actually provide a lecture on the Parliament, the Commonwealth Parliament, and especially the tension that exists between the power of the Commonwealth Parliament to pass laws as opposed to the power of the state parliaments to pass laws, and these are often in conflict, or these could be in conflict with each other. So I've kind of talked about the Commonwealth Parliament. Here, I'll be focusing now on the executive, and then I'll also be talking later on in a different lecture podcast about the judiciary. And so the reason why the focus now is on the executive is that, as we know, there are often three in any government, in any democratic government anyway. There are three branches of government. You have the executive, you have the parliament or the legislature, and you have the judiciary. And in order for there to be the limits or constraints on the exercise of government power, we often look at it in terms of three branches of government because one branch of government often acts as a check and a balance on the other powers of government. Imagine a scenario where you have a single individual, and you might call him the executive or the king or the emperor or whatever, and that particular individual is the executive. In other words, he executes the laws and ensures that laws are maintained and followed. And then that particular person also has the power to make laws. And then that person is also in a position to decide and act as the judiciary in the sense that he makes judgments as to whether or not the law has been followed or obeyed or violated. So in that particular scenario, you have a troubling situation where you have a single individual or an institution who wields both the executive power, the legislative power, the power to pass laws, and the power to interpret and decide whether laws have been broken. And that is an autocracy. And it does happen even today, surprisingly, in a few countries. And you're probably talking about North Korea, where you have an autocrat. Perhaps you may argue that's also true in the case of Russia at the moment, in the sense that although you may have, the president actually dictates upon the Duma or the legislature on what the laws are meant to be. And then because of the strong powers of the president or the executive, even the judiciary have to bow to whatever the president says out of fear that they could be imprisoned or they could even be killed. So in that particular scenario, again, there is no checks and balance, and you do have a scenario where there is an autocrat or a dictator whose word is the law. And so it is in this context that we consider the executive and the powers of the executive in relation to the powers of the parliament and the powers, for example, of the judiciary. So we're going to be looking at this today in that context. And in doing so, I will also try to draw a comparison with the US presidential system. So I'm using the United States as an example, mainly because a lot of us are quite familiar with the nature of government in the United States. And we note as well that both the United States and, of course, Australia are representative democracies. And so it's going to be interesting to examine where, given the fact that you have a presidential system of government in the United States and a parliamentary system of government in Australia, and both are actually representative democracies, how exactly then are they distinct in terms of the operation of these concepts, and especially in terms of the so-called checks and balances in the United States, for example, because there is complete separation of powers. So they function differently. In Australia, we only, at least at the level of the Commonwealth, we only have a partial separation of powers because, as we see, the executive, especially in the form of the prime minister and the cabinet, are also part of the parliament. And so, in a sense, you can't really say that the executive provides a check and a balance to the powers of the parliament. And because in that sense, it's often the prime minister and his cabinet because they're part of the parliament, and they're often the leaders of the party. They do, in a sense, dictate what happens in parliament. And so, in a sense, when you talk about the power of the parliament to police and regulate the activities, or be a balance to the strong powers of the executive, you begin to wonder, is that really true, given the fact that the members of parliament also involve members of the cabinet and the prime minister? So that's an interesting thing we're going to be looking at today. And then when we talk about the executive power, for example, we wonder, where exactly does the executive power come from? And is it all in the Constitution? The problem there appears to be that when you talk about the Constitution, there is even no reference to the prime minister or the cabinet. So how is it that when we talk today about the executive power, we know that the head of government or the head of the executive is actually the prime minister and not the governor general, who's actually identified in the Constitution? So that, in a sense, that becomes a perplexing question. You've got the governor general identified in the Constitution under Section 61 as representing the executive, and yet we know that the executive, we know that the governor general exercises only ceremonial powers, and that the actual person who wields the power of the executive is the prime minister and his cabinet. So we're going to be looking at that as well, and we'll have a chance to briefly talk about executive power, quasi-legislative powers, and quasi-judicial powers towards the end of this lecture. Okay, so after studying this topic, you should be able to discuss and explain the concept. I've done it twice. The concept of responsible government and collective responsibility, and provide an overview of Commonwealth executive powers. So let's begin by talking about representative government. It's not really in the Constitution. The Constitution does not explicitly say that the government is representative. We know, however, that our government is a representative government, given the fact that it is the people, at least the citizens of Australia, who do elect the members of the parliament, both the House of Representatives and the Senate. So given the fact that there's a direct election by the people, in other words, the Australian citizens, then we know that the members of the Senate and the members of the House of Representatives are meant to represent the people. And when we ask, therefore, what is the legal basis or the political basis for the ability of the Commonwealth Parliament to pass laws, it is the fact that they have been directly elected by the people. They represent the people, in other words, and that provides legitimacy to their ability to pass laws. In a sense, when you talk about representative government and the ability of the Commonwealth Parliament to pass laws, for example, you also ask the question, given the fact that you do have, three branches of government, and we're going to be looking at this in greater detail in a short while, but when you look, for example, at the executive, both in terms of the governor general not being elected by the people, and you look at the prime minister and the cabinet, who are not directly elected by the people, can you even say that the executive, represents government when they haven't been elected by the people? The same question arises in relation to the judiciary, because the judiciary is clearly appointed by the executive. And so in that sense, because they are appointees and they are not elected, why should they be part of the concept of representative government? And yet we know that at its core, when you do look at the Australian Commonwealth Constitution, implicit in it are the values of representative democracy and representative government, given the fact that at least as far as the power to make laws is concerned, we know that those who wield the power to make laws are the members of parliament who have been directly elected by the people. In the case of Attorney General Western Australia and Marquette, Justice Kirby stated that the concept of representative government or representative democracy has been repeatedly held to be a crucial feature of the system of government which the federal constitution establishes. So although it's not explicitly indicated in the constitution that we are a representative democracy or that we have a representative government, the fact that the members of the House of Representatives and the Senate are directly elected by the people indicates strongly and demonstrates the fact that we are a representative government or a representative democracy. And the idea of representative government and representative democracy are crucial values, especially because when we talk about questions later on about laws that may be passed that in a sense interfere with what are known to be common law rights or rights recognized by the courts as being part of the fabric of Australian society, the question often arises is that would these laws contravene the notion of a representative democracy? In other words, it's basic that as far as the Australian Commonwealth is concerned and its constitution, it is derived from the idea that it is democratic. So in other words, if there is any law that appears to contradict the notion of democracy, and especially the notion of representative democracy, it is likely the case that even though it may be said that the Commonwealth Parliament actually has the power to pass a law in relation to a particular subject matter, it is tempered and controlled and regulated by the idea that that particular law must not contravene notions of representative government or representative democracy. So it is a fundamental feature of the federal constitution that we are a representative democracy. And this will relate later on to a discussion about constitutional rights and freedoms, so that as we will later on, fully examine, there is the implied right to political communication. So in other words, when there is a restriction, for example, on the ability of individuals to be able to make a statement or be heard in relation to political matters, on the basis of a law that is passed, you begin to ask the question of whether or not that law would be unconstitutional in the context of the idea of a representative democracy as enshrined in the Constitution implicitly. And of course it is, follow the case of land. So what it also means is that the idea that you have a tyranny or an autocracy or even a dictatorship would be abhorrent to Australia's system of government. Okay, now let's examine further the idea of government mandate and democracy. So the basic mandate of at least the executive, as far as the executive is concerned, it is actually based on the Constitution as the legal foundation, as we see later on, because the idea of the power of the executive could clearly be seen under Section 61 of the Australian Commonwealth Constitution. But as we will examine later on as well, the powers of the executive the powers of the executive do not exclusively come from the Constitution, because as we see later on, it is very common for the Commonwealth Parliament to actually pass a law providing greater powers to the executive and authorizing the executive to act in a particular manner. So in that case, the executive then wields more power as a result of legislation passed by the Commonwealth Parliament. And more importantly, as we see later on, there's the idea of what are known as quasi-legislative powers. And this relates, for example, to the ability of the Commonwealth executive to actually pass regulations and policies that do control and regulate the activities of individuals. And when we examine the principle of legality in a short while, we will see that this ability of the executive to pass regulations, or what are known as quasi-legislative powers, may in a sense conflict with certain common rights of individuals. And it is because of the requirement of the concept of principle, the concept of the principle of legality, which we examine shortly, that there is a requirement that if there is any act on the part of especially the executive government, that interferes or impairs with common law rights of individuals, then that interference or impairment must be justified on the basis of a statute or on the basis of some positive law, in which case this can involve the regulations passed by the Commonwealth Parliament as a result of an authorization based on a law or a statute passed by the Commonwealth Parliament. So we're going to be examining that later on. So as far as the mandate of the executive is concerned, it's the foundation is the Constitution, and of course you do have the electoral legitimacy through suffrage, in the sense that we know that the Prime Minister and the Cabinet are members of Parliament, and therefore they've also been elected directly by the people. We also have to consider that at the end of the day, you do require an executive in any government. You can't just have a government where you only have the judiciary and the legislature or the parliament, because somebody has got to be able to execute the laws and maintain the laws of a particular government and ensure that needs of people are met. And so there's a requirement that you always need an executive. In fact, it could be argued that you may be able to do away perhaps with the parliament, especially if the president, like in a dictatorship, will be able to wield lawmaking powers. But you can't have a government without an executive, without a leader. And so that's just part of the framework of any government, that you do need the executive. As far as historical contexts are concerned, we do know that the idea of democracy emerged in ancient Greece. But at that time, given that ancient Greece had a very small population, then it was very easy for people to be able to directly, elect their leaders. And when they did, this was known as a direct democracy, because in that case, you can say that whoever, for example, was the prime minister or the cabinet were really elected directly by the people. But when we look at governments now, it's not possible for for a prime minister, for example, to be elected by all individuals, because even as far as Australia is concerned, we know that every state, at the level, for example, of the states, the members of the House of Representatives are chosen by the electorate in a particular electorate, and it is eventually the members of the House of Representatives who then choose the prime minister. So in that case, as far as the prime minister is concerned, the prime minister wasn't directly elected by the people, but elected by the members of parliament. Now let's have a look at presidential and parliamentary systems of government, just to see the differences between presidential systems and parliamentary systems. So if you look at the United States, for example, we know that the president, who is the executive in the United States, is directly elected by the people through a popular vote, in a sense. So in the United States, the one who becomes president can be said to have been elected by the people, although the nuance as far as the United States the election of the president in the United States, the nuance there is the fact that it is actually the United States Electoral College system who votes for the United States president. So in the United States, for example, based on the popular vote for a particular US presidential candidate, a certain number of electors who then go to the Electoral College are chosen. So there's an apportionment of members of the US Electoral College based on their respective populations. And it is eventually these members of the Electoral College who then elect the United States president. So in a sense, again, you can see that the idea of the president having been directly elected by the people isn't really true, because ultimately the election is done by the members of the Electoral College. This is clearly demonstrated in the fact that, for example, during the elections between Al Gore and President George W.H. Bush, it was actually Al Gore, who was a Democrat, who won the popular vote. And yet, it was President George W. Bush who became the president of the United States. So there were actually more votes cast by the general electorate in the United States, but it was George W. Bush who was elected eventually as the United States president on the basis of the US Electoral College system, given the nature of the apportionment of votes in the US Electoral College, which is really based on population of a particular state. So what it means is, in many cases, depending on the laws of a particular state, it's almost like it's winner take all. So even, for example, let's assume, like, you've got a state such as Michigan, and let's assume that 60% of the votes are won by, let's say, George W. Bush in the past, and then 40% was won by Al Gore. But given the nature of the winner-take-all apportionment of votes in the U.S. electoral system, all the members of the U.S. electoral system of the delegates from Michigan may all end up voting for just one single candidate. It all depends on the particular rule. So in a sense, it's not so much about the popular vote, but really the apportionment of votes in the electoral system. It's different, of course, from the parliamentary system of government that we have, for example, in Australia, because the Australian citizens, do not vote for the prime minister. In fact, we don't have a say. The prime minister is chosen by parliament. The other distinct difference is that, given the fact that in a parliamentary system, the prime minister is accountable to parliament, what it means is that when the prime minister, for example, loses the confidence of the lower house, or the House of Representatives, or the parliament, as headed by a particular political party, headed by the prime minister, fails, for example, to pass a law on supply, in other words, pass a law on the budget, then in that particular case, the prime minister and the cabinet will fail. So in a sense, it is very possible that after there have been parliamentary elections during which members of the House of Representatives and the Senate have been chosen, you would think that the prime minister who has been elected or chosen by the House of Representatives will be there for quite some time. That doesn't happen in many cases, because it is very possible that there will be changes in relation to who the prime minister is in the course of a particular sitting of the House of Representatives. And in that case, therefore, and you can see this in some parliamentary systems where maybe even in a single year, you can have 3 different prime ministers and even 3 different sets of cabinets during a particular year. So in a sense, there's that element of unwieldiness and an element of instability in parliamentary systems of government. But in a sense, the argument there is that when you have this system of government, which can be considered to be unstable because the prime minister can be deposed, it also guarantees that there is a strong element of accountability on the part of the prime minister and his cabinet to the parliament. So in other words, if the prime minister and his cabinet do not do their jobs, then it may be possible that the House of Representatives, at least in Australia, may pass a vote of lack of confidence, which can then trigger a dissolution, which can then mean that the prime minister will have to step down, and then enable the House of Representatives to choose a different prime minister. And in some cases, it may even mean that it can trigger a dissolution of the entire House of Representatives if they are not in a position, for example, to come up with a prime minister and a cabinet who will be able to secure the needed votes from the House of Representatives. In the United States, for example, there is greater stability as far as the US president is concerned, because the US president is elected for a term, for example, of 4 years, if I'm not mistaken. And during that time, it will be very difficult for the US president to be unseated. The US president can only be removed from office through a process of impeachment. And that's a difficult task, because for the US president, for example, and we've seen this attempt on the part of the, in the United States, attempts to impeach the US president, but that becomes very difficult because you need a majority vote, if I'm not mistaken, as far as the US House of Representatives are concerned. But then you need a 2/3 vote from the United States Senate convicting the president, because there are clear grounds upon which a US president, for example, in the United States can be impeached, like, high treason, and, high crimes and so on. As far as the parliamentary system, on the other hand, is concerned, there is no requirement that the prime minister is unseated or deposed or removed from office on the basis of having committed a crime. It is enough the prime minister fails to pass supply, or it is enough that the House of Representatives has lost its confidence in the prime minister, and that is sufficient for the prime minister to then lose his or her office. Okay, now moving on. So in terms of the implications, which I've kind of discussed, so as far as the presidential system is concerned, the president has a fixed tenure in the United States of at least, is it 3 or 4 years? Probably 3 years, I think, if I'm not mistaken. So that ensures stability, but in a sense, there is less accountability, because what it means is that, to a great extent, because the United States president is aware that he doesn't have to rely on the United States Congress for him to continue in power. He can just disregard, whatever whatever Congress thinks. But that then leads to oftentimes a clash between the two branches of government, especially when it comes to the budget. And we see this happening in the United States, where there is a need to fund the activities, for example, of the federal government, and there is a deadlock in Congress. And that poses a dilemma, because, if a budget is not passed, what it means is federal government workers don't get paid, including those in the military, for example. And that causes a problem. So there's a lot of political stalemate and political deadlocks and political issues in the United States. In a sense, in Australia, it's a bit different, because the moment there is a problem concerning the budget, or the inability of the House of Representatives, as headed, for example, by the ruling party, to be able to pass a law concerning supply or the budget, then it will have to mean that the prime minister and his cabinet fail, and there will have to be an election or a vote for a new prime minister and a cabinet. So there would be government instability only upon a loss of majority support in the House of Representatives. And so therefore we see that the executive, at least the prime minister and the cabinet, are very dependent on parliamentary support. But in a sense, this problem is ameliorated by the fact that the House of Representatives, who elect the prime minister, is often operated or controlled by the ruling party. So it's the ruling party that determines who ends up becoming the prime minister. That can often be problematic, though, in some parliamentary systems, where, and this is often true in New Zealand, where you see that you don't have two dominant parties that we do have in Australia, because in Australia, for example, at the level of the Commonwealth, it's between the Labour Party and versus the National Liberal Party. So these are the two main parties. But so which means, if the prime minister has been chosen, for example, by the National Liberal Party or the Labour Party, you can be sure that the prime minister has direct support of the ruling party in the House of Representatives. In New Zealand, for example, and in France and in other parliamentary systems, it becomes more problematic, because you don't have two dominant political parties, but you do have third parties, which can have, it's not just two political parties having the votes to, to be able to elect by a majority vote the prime minister in some countries, such as I mentioned, such as France and New Zealand, because there are third and even fourth parties that have strong representations in the House of Representatives. The prime minister who is elected must try to secure the support of other political parties. And in that case, therefore, we can see that the confidence or the stability of the position of prime minister is not dependent on just one ruling political party, but a coalition of political parties. Okay, so as far as the executive is concerned in a parliamentary system, this is based on the provision of Section 61 of the Australian Commonwealth Constitution, which provides that it is the executive who has the power to execute the laws of the Commonwealth and to maintain the laws of the Commonwealth. And it's curious because, as I mentioned, the executive power mentions that it is wielded by the Governor General, and there is no reference to a prime minister. So how is that possible? That although the Australian Commonwealth Constitution under Section 61 provides that the executive power is wielded by the Governor General, how is it that in reality it is actually the Prime Minister and the Cabinet who wield executive power? And so, how exactly did that happen? And we know that the Governor General is just a ceremonial position. And as we will see, it's actually based on convention and common law interpretations. In other words, the way that the courts have interpreted the Constitution. So, for example, what are conventions? So conventions are long-established practices and values that govern the way that the executive and the parliament act. And it would be because they are long established traditions and practices that have certain values underpinning them, it will be very difficult. So it's almost like norms. It's very difficult to disregard them. It's almost like it's a cardinal sin to violate certain conventions. It's almost like, when we talk about certain norms, we do have a norm in basic society where we need to be decent. We avoid being racist. So the moment we violate these norms, there is moral retribution. There is social disapproval. But in regard to political conventions, for example, it just becomes so unheard of that, for example, the Governor General will go against the advice of the Prime Minister, and it can even lead to a constitutional crisis. In the case of the Gough Whitlam government, was that in the 1970s, where on the basis of the actions of the Governor General Kerr, he decided to choose a different prime minister. That was, in a sense, a constitutional crisis, because, in a sense, there were those who argued that the Governor General overreached, because as far as the choice of the prime minister is concerned, it is meant to be based on the choice of prime minister from a vote by the House of Representatives. So when you talk about conventions, because there are long established traditions and practices, it's just so difficult for members of parliament or the executive to disregard them. It's almost like you need to obey this, even if they are not in the Constitution explicitly, but it's implicit that they are actually part of the fabric of the Australian Constitution and Australian democracy. As important as well, when it comes to the executive powers of the Commonwealth, we know that the courts, especially the federal courts, also are important in terms of defining who the executive is and what the powers of the executive are in our parliamentary system of government. And the High Court had an opportunity to explain this in Sue and Hill, where the High Court said that the government describe the government or the executive government as being the executive, as distinct from the legislative branch of government, and that the executive is actually represented by the ministry and the administrative bureaucracy which attends to its business. So, in other words, there is recognition in the case of Sue and Hill that when we talk about the executive government, it's not the governor general, but the ministry and the administrative bureaucracy which attends to its business. On this point, I'd just like to elaborate on that point about administrative bureaucracy, because we do have this idea now that the prime minister, in a sense, is part of the notion of representative government and representative democracy, because they have been elected. At least the prime minister has been elected by the members of the House of Representatives, and the House of Representatives have been directly chosen by the people. And so, to an extent, the prime minister then is emblematic of the idea of representative democracy and representative government. But when we talk about the administrative bureaucracy, for example, it could be the Australian Taxation Office, it might be the Australian Security and Intelligence Organization, or some other ministry or bureaucracy in the Australian Commonwealth Government. We know that these bureaucrats, it seems to be a bad term for some, but these government officials who are part of the ministry or administrative bureaucracy have not been elected by the people. They have been appointed, for example, by the prime minister or the members of the cabinet. So we know, therefore, that although we can argue that the ministry are elected, or at least, embody the idea of representative democracy, you can't really say about members of the administrative bureaucracy because they're appointees of the prime minister and the cabinet. Now, moving on. So when you look at the idea of the crown, the executive is composed of the ministers, public servants, the cabinet, and the executive council. The executive council has recognition in the Constitution, I think under Section 57 of the Australian Commonwealth Constitution. But the executive council, as we know, although it has explicit recognition in the Constitution, is distinct from the prime minister and the cabinet. In fact, the members of the executive council are not necessarily part of the cabinet, so they're distinct. So in a sense, to a great extent, the executive council may include, senior members of the cabinet, but not all members of the cabinet are necessarily part of the executive council. And so, on the one hand, you do have the executive that undertakes the role of administering the laws and making sure that the needs of its citizens and the people of Australia are met. That's through the prime minister, the cabinet, and the public servants, and the bureaucracies. On the other hand, you do have the Governor General, who has been recognized clearly under Section 61 of the Australian Commonwealth Constitution as being the executive, but again, only having a ceremonial role. And that is mainly because of, as I mentioned, because of convention. So based on long-established practices and traditions that members of government simply have to follow. And so when we talk about the role of the crown and the executive, and we talked about checks and balances, ultimately we ask a question as far, who then would the crown and the executive be responsible to? And where does accountability lie? Because there appears to be some level of shared responsibility among various institutions. So we're going to look at that in greater detail in the next slide here. So when we talk about the idea of representative government, the idea really is that at the end of the day, the executive branch of government in the form of the cabinet and the ministers, they are accountable to the legislature, to the parliament. There is no such thing under a presidential system of government, because the United States president and his cabinet or her cabinet, the United States hasn't had a US president yet, but who knows, after this lecture podcast, it may be Kamala Harris who becomes U.S. president. But in general, in the United States, for example, the executive branch of government is not accountable to the legislature. The U.S. president is accountable directly to the people. But in Australia, the executive branch of government is accountable to the legislature, and the executive government, at least the prime minister, relies on the confidence of the House of Representatives. When the House of Representatives loses confidence in the prime minister, or the House of Representatives is unable, as in a sense, led by the prime minister and the cabinet, are unable to pass supply in the form of coming up with the budget, then in that case, the government will have to fail. So there's that level of accountability. And this is also the reason why you can see the prime minister and the cabinet really being part of the House of Representatives. It's a requirement that the members of the cabinet and the prime minister are part of the parliament, whether at the level of the House of Representatives or at the level of the Senate. They have to be part of the parliament. And you will see then the prime minister being quizzed, for example, during question hour. You don't see this in the United States. The United States only probably visits the U.S. Congress every year to have the annual speech, but there is no accountability as far as the U.S. presidential system is concerned. And as far as the Australian parliamentary system is concerned, you will see that the prime minister and the cabinet are part of parliament. On the point about convention, for example, again, there is nothing which says that the prime minister must come from the House of Representatives. In theory, there is no requirement. But by convention, the prime minister of Australia and even in the United States, in the United Kingdom, have to come from the House of Representatives and not the Senate. But that is by convention. Now, the idea, therefore, of representative government being, the executive being responsible to the parliament, means that by extension, the executive is responsible to the public, because, as we recall, the members of the House of Representatives have been elected by the public, and the public, determines who are members of the House of Representatives. So, because of the idea that the executive, in the form of the prime minister and the cabinet, have to report and be held accountable by the parliament, they are, in a sense, by extension, also accountable to the public, in theory. So it's important, as I mentioned, that the executive must maintain majority confidence in the lower house, and if in the event that that confidence is lost, they must resign or possibly call for an election. So in other words, if the confidence is lost, it doesn't have to follow that there has to be a dissolution of the House of Representatives. It doesn't have to follow. It can simply mean that the prime minister will resign and the House of Representatives will elect a new prime minister. And we can see this in the form of potential changes within a particular political party which decides that the current prime minister belonging to a political party must be replaced by another prime minister belonging to the same political party. But in the event that a particular ruling political party is unable to get the votes to elect a prime minister, in the event that a particular prime minister steps down, then it may mean that there will have to be elections to be called. And in that particular scenario, the hope of a particular ruling party is that they will then secure more votes to then clearly have a majority control in the House of Representatives. Part of the idea of representative governments is the idea of ministerial responsibility. So here, the ministers can be held to account for their own actions or the actions of their department, and they can be called to task by the House of Representatives, for example, or by the Senate, and they have to justify their actions. And especially in the form of question time, where they could be really interpellated and interrogated by the other members of the House of Representatives. In the United States, again, this is not the case, because to a great extent, the cabinet secretaries in the United States don't really have to report to the U.S. Congress, although they do report to the United States President and are therefore accountable to the United States President. They can also be required to resign for serious errors or misjudgments in the event that there are certain ministers who breach their duties. And this can be in the form of the danger that, if the prime minister does not take political action against a particular cabinet minister, the entire government may fall. And, it becomes a big political issue if there is a minister, for example, who engages in sexual misconduct, who is permitted to continue to stay in office. That becomes a big political problem for the prime minister and the cabinet, which will then mean that at some point, the prime minister will be forced to let go of a particular cabinet minister. Now, speaking of the cabinet, as we mentioned, are often senior ministers, and they make key government policy decisions collectively, in theory, mainly because it's because the members of the cabinet are chosen by the prime minister. Although the idea is that decisions are made collectively by the cabinet, including all the senior ministers. In a sense, in reality, that's not really true, because the prime minister has an outsized influence and power, informal power within the cabinet. So if a senior minister, for example, does not toe the line, then it's likely the case that the particular minister will end up being removed as a cabinet minister and go back to even be relegated to the backbench. So in a sense, when we talk with the parliamentary system of government, we have the idea of primus inter pares. It's a Latin term meaning first among equals. So the prime minister, although in a sense they're equal, is actually first among equals. So it's a common description of a parliamentary system where you have the prime minister being primus inter pares, or head first among equals. The idea then of responsible government as well is that all cabinet ministers must publicly support decisions once they are made. And it would be a breach of convention for a cabinet minister to disregard a policy decision that has been made by the cabinet. In that particular case, if there is gross disagreement, it's likely the case that the cabinet member or minister will be thrown out the door and lose the position as a cabinet minister. So that cabinet minister must toe the line once a collective decision has been made. Now, the idea of responsible government really rests on the view that the executive is responsible and held accountable by the parliament. And so what that means is that as far as the executive government is concerned, there is a requirement under the Constitution for approval from the parliament for all expenditures and taxes, as we see in the Constitution. And that ensures that there is some level of legislative or parliamentary oversight over the actions of the executive, all part of the idea of responsible government. So here we talked about ministerial responsibility, but here this is the idea of collective responsibility as well. So that's cabinet's role as part of collective responsibility. So at the end of the day, the entire cabinet has collective responsibility to Parliament. Now, the idea of responsible government has been discussed in the case of New South Wales and Bardolph, a case decided in 1934, where the High Court, through Justice Dixon, said it imposes on the administration a responsibility to Parliament, or rather to the House, which deals with finance for what the administration has done. So there is recognition of the idea of responsible government through the courts. In the case of Lang and Australian Broadcasting Corporation, the High Court also stated that Section 62 and 64 of the Constitution combine to both provide for the executive power of the Commonwealth to be exercised on the initiative and advice of ministers. So we've discussed it, but what are some of the means of enforcing responsible government on the part of the executive? So Parliament meets at least annually. So what it means is, in the United Kingdom, for example, in history, they had histories of what are known as prorogation, during which time the king could just, summon the parliament. And for a while, he may decide not to summon the parliament at all, even for maybe a year or 2 years, which meant that there is no parliament. But that can't be the case in Australia because parliament must meet at least annually. And because the parliament meets at least annually, then we know that the prime minister and the cabinet will continue to be held to account by the parliament. One of the other means of enforcing responsible government would be the provision of control, will be the provision for control of supply or budget by the legislature, requirement that ministers must be members of the legislature. There's also the privilege of freedom of speech in debates in the House of Representatives, which means that government ministers, members of the cabinet, and even the prime minister can be interpellated and interrogated and questioned by the House of Representatives or even in the Senate. There's also the power to coerce the provision of information, to provide the means of enforcing the responsibility of the executive to the organs of government. So they can be compelled to provide information to the parliament, except, for example, in those cases where there may be national security reasons why information shouldn't be provided to the parliament. I mentioned already that we talked about collective responsibility. Members of the cabinet are collectively responsible as a government. If the government loses the support or confidence of Parliament, the prime minister must tender the resignation of the entire ministry. So the members of the cabinet stand or fall together. And so, as I mentioned, even if there is a disagreement among the ministers in cabinet meetings, once a decision has been made, they must support that decision. They are not permitted to show discord or disagreement in public. Otherwise, that particular minister who disagrees with the collective decision of the cabinet is likely going to be kicked out and shown the door by the prime minister. So that's collective responsibility. But the other aspect to it is the idea of individual ministerial responsibility, where the ministers must account for their actions by answering questions in Parliament, and they must resign when they're guilty of personal misjudgment or negligence and so on. So what happens when there is a loss of parliamentary support on the part of the cabinet? So the executive government that loses the support or confidence of Parliament apparently cannot govern, because what it means is that there will be no law that is passed, the law for supply. So there won't be any law that would enable the executive, for example, to fund the activities of government. And so in that case, they will have to resign by convention, because it is the Parliament that controls government access to finance. And so without money, without the budget, without finance, there is no money to pay for the ordinary services and activities of government. And it's also clear that under Section 81 of the Constitution, all revenue of the Commonwealth must be paid into the Consolidated Revenue Fund. So it won't be permissible, for example, that any taxes collected by the Australian Taxation Office are then put into a separate fund, which is a part of the Consolidated Revenue Fund. That would be impermissible under Section 81 of the Constitution. And because all revenues collected by the Commonwealth through taxes, through customs duties, or maybe even for certain regulatory activities, they must go into the Consolidated Revenue Fund. It means that money within the Consolidated Revenue Fund can only be allocated or distributed or paid out on the basis of a law passed by the Commonwealth Parliament. And this is clearly stipulated or stated under Section 83 that no money shall be drawn from the treasury of the Commonwealth except under appropriation made by law. In other words, law passed by the Commonwealth Parliament. So the power to pass laws that appropriate money for the ordinary annual services of the government lies with Parliament, which really emphasizes the importance of responsible government and the strong powers exercised by the Commonwealth Parliament over the executive, over the Prime Minister and the Cabinet. So in terms of losing parliamentary support, that is in the form of the government being denied supply by the lower house. So the lower house refuses to pass a law appropriating revenue or monies for the ordinary annual services of the government. In that case, when the government loses support, the Prime Minister and the Cabinet will have to step down, and the new Prime Minister will have to be elected. In some cases, it will have to mean that a new election will have to be called. A new election of members of the House of Representatives, who at some point, hopefully, will be able to garner majority control of the House of Representatives, who then choose the Prime Minister, who will then appoint the members of the Cabinet. The other way by which the Prime Minister and the Cabinet will lose support will be in the form of a resolution expressing so meaning there has to be a resolution that passes, right? The resolution passes by majority vote, expressing lack of confidence in the government, or rejects a resolution declaring confidence in the government. In this scenario, it is very uncommon for a member of the ruling party or a member of the party that has elected the Prime Minister to vote against his own party. But this can be very important when you have a Prime Minister who has been chosen on the basis of a coalition, in the sense that you have multiple parties who have enough votes in the House of Representatives, for example. So unlike a scenario where you have one dominant political party, such as, for example, the Labour Party, you may have a situation where for a Prime Minister to be voted, the Prime Minister who is eventually voted by the House of Representatives must be able to secure the support, for example, of the Greens Party or some other party. And in which case, the moment, for example, a member of the coalition refuses to provide continuing support for the Prime Minister, the Prime Minister will have to be unseated. Now, but then we ask, although we talked about responsible government in the sense that it is the executive being responsible to the parliament, is that really true? Or is that really a fiction? And this is a point raised by the authors Ratna, Pala, and Crow, because they are actually, in a sense, argue that it's not so much the executive being, accountable to the Commonwealth Parliament, but in a sense, it's actually the Prime Minister and the Cabinet having a greater control over the Parliament. And the reason for this is that because the Prime Minister and the Cabinet are part of, for example, are part of the Parliament, and they are part of the ruling party, it means that although in theory, they report to the House of Representatives, it's actually the Prime Minister and the Cabinet who can determine what the laws ought to be that will be passed by the House of Representatives, because they are part of the House of Representatives in the first place. Or it could be that some of the cabinet ministers are part of the Senate. So because in theory, in reality, the members of the Prime Minister and the Cabinet are part of the Parliament, and they are part of the ruling party, they can actually determine what the laws are. So it's only in theory. The Prime Minister is not going to be reporting to a junior member of the ruling party, or it's not going to be possible for a member of the same ruling party to which the Prime Minister belongs to question the Prime Minister in a very aggressive manner. It just can't be done. That particular member of Parliament is likely not to be chosen as the representative of the political party in the next election. Or it could be that somebody who is meant to be senior ends up becoming part of the backbench, and so with limited ability to speak out. So in practice, therefore, the members of the majority party, especially the backbenchers, defend the actions of the executive. So moving on, let's now examine what exactly are the sources of executive power. We've talked about Section 61 of the Australian Constitution. We'll talk again as well of statute law or statutes passed of the Commonwealth, authorizing the executive to wield certain powers, both the power to do certain things executively and the power, for example, to even pass quasi-laws. in what is known as quasi-legislative powers, and then we'll talk more about common law prerogatives. Now, going to the point about Section 61, Section 61 of the Constitution expressly provides that the executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor General as the Queen's representative, and extends to the execution and maintenance of this Constitution and the laws of the Commonwealth. Of course, today, we're no longer talking about the Queen, but of the King of England, who at the moment is Prince Charles. And although the reference there is to the Queen, we don't really have a Queen or even a King in Australia, but that reflects the fact that the Governor General, in a sense, is representative of the King of the United Kingdom, who today is Prince Charles. Sorry, not Prince Charles, King Charles. He used to be Prince Charles. So in practice and by convention, it is the Prime Minister and the Cabinet, as I mentioned, who wield executive power under the Westminster parliamentary system and the principle of responsible government, which I mentioned. So even though reference is to the Governor General as representative of the Queen, in actual practice and by convention, it is the Prime Minister and the Cabinet who actually wield executive power. In the case of Barton and the Commonwealth, cited in Davis and Commonwealth, the High Court, through Justice Mason, said that the power of the executive extends to the execution and maintenance of the Constitution under the laws of the Commonwealth. It enables the Crown to undertake all executive action which is appropriate to the position of the Commonwealth under the Constitution and to the spheres of responsibility vested in it by the Constitution. So now let's talk about the grant of power to the executive, broadening the powers of the executive. So we know that it is very possible for the executive to interfere with the rights and freedoms of its citizens and of the people in general. And what this means then is that, given the principle of legality, which based on the case, for example, of Entick and Carrington, and Regina and Somerset County Council, cases decided in the United Kingdom, there is a requirement under the principle of legality, which I mentioned before, that for any law or any act of the executive that interferes or impairs with common law rights and freedoms recognized by the courts, there has to be a positive law that would allow this. So, for example, it will not be permissible for members of the Australian Federal Police to just seize, phones that they see being used by individuals outside, or just prohibit the peaceful exercise of political activity, because that, in a sense, would impair or interfere with recognized political freedoms in Australia. If there is an attempt, an attempt, for example, on the part of the Australian Federal Police to, at random, just stop people on the street to check, if they have any valid reason for being on the street, these types of executive action will require a statutory grant or a grant from the Commonwealth Parliament through a law, because of the principle of legality, that when there is an interference of common law rights and freedoms recognized by the courts, there has to be a positive law in the form of a statute that would justify it, or at least on the basis of certain principles derived also on the basis of common law. So what then happens is that it would not be uncommon for the Parliament to confer powers on the executive, especially coercive executive powers. So, for example, the power to conduct surveillance of Australian citizens who might be suspected of committing certain crimes. The executive on its own can't do this. It has to be based on a law passed by the Commonwealth Parliament, because clearly acts involving surveillance of ordinary citizens will mean an interference with common law rights of individuals in Australia, for example, the freedom of, to be free and the freedom from government interventions. In that case, that will require a positive law. So the Commonwealth Parliament will then pass a law that will authorize the Commonwealth Executive to act in a particular manner, especially if it ends up interfering with certain common rights and freedoms. So we've talked about the basis of the power of the executive based on Section 61 of the Constitution. We've also talked of a statutory grant of power. And then there are certain common law prerogatives as well. So, for example, it's been recognized by the court in Davis and Commonwealth, for example, that there are certain powers of the Commonwealth that are considered to be prerogatives or discretionary powers. They're not in the Constitution. They're not based on laws passed by the Commonwealth Parliament, but they are considered to be an inherent power of the executive. So, for example, and for example, the case in Attorney General and the Kaiser's Royal Hotel Limited, the court in the United Kingdom stated that as far as executive prerogatives are concerned, they are part of the residue of discretionary or arbitrary authority, which at any given time is legally left in the House of the Crown. So, in other words, as far as the power of the executive is concerned, it is not limited to that which is derived from the Constitution or limited to the laws authorizing certain executive action through statute, but there are certain discretionary or powers or prerogative powers that inhere in the executive. So, for example, in the case of Pape and Commissioner of Taxation, the High Court recognized or stated that executive powers as may be conferred upon the executive by statutes may be made. Hang on, how do you read it? So executive powers include those as may be conferred upon the executive by statute made under the Constitution. So that's plainly included, but so are the prerogatives of the Crown. For example, the power to enter into treaties and to declare war. So that is a prerogative. So the power, for example, you wonder if the Prime Minister decides to go to war in Ukraine, or or involve its army in Ukraine, or involve the ADF in an expedition in Afghanistan or Somalia or whatever, or the power to declare war, wouldn't that require parliamentary authority, especially because under the Section 51 of the Australian Commonwealth Constitution, the Commonwealth Parliament has the power to pass laws in relation to the defense, naval and military defense of the Commonwealth and of the states, as well as the external affairs of the Commonwealth. So why would, in that scenario, wouldn't the Prime Minister require parliamentary authorization in the form of a statute before it can declare war or enter into treaties? And the answer is no, because it is recognized by the High Court, for example, that there are certain prerogatives or discretionary powers in the executive. This also includes, some of these prerogative or discretionary powers includes the power to enter into a contract. So there is no requirement that there has to be a statute that authorizes, for example, the Prime Minister or the cabinet member to enter into a contract. It's an inherent power. And so we will see, therefore, that the power, for example, to grant pardons, the power to confer awards, these are, again, all part of what are known as discretionary or prerogative powers, which do not require parliamentary approval or authorization through statute. So finally, let's talk about scope of executive powers under the Constitution, particularly Section 61. The executive has the power to execute and maintain the Constitution and the laws of the Commonwealth. That's actually quite broad. The power to execute and maintain the Constitution and the laws of the Commonwealth. It will have to mean that for the executive to be able to fulfill that particular power or accomplish that particular power, that has to be interpreted broadly. So that's a scope of the executive power. The limitation would have to be those that are limitations imposed, for example, by the requirement of the principle of legality, limitations as indicated in the Constitution, both expressly and implicitly, based, for example, on the idea of representative democracy, the fact that we are a democracy. The other power that we will often see, and we're going to be looking at this in greater detail, is what are known as quasi-judicial powers. And so we know what judicial is. So judicial powers involve the power of the courts to interpret laws, but more importantly, the power of the courts to deal with a matter. And we're going to be looking at this in greater detail later on. But we know, for example, that there is an institution such as the Administrative Appeals Tribunal. So as an example, as far as the Administrative Appeals Tribunal is concerned, the Administrative Appeals Tribunal, which is a federal administrative body, in other words, it is a body that belongs to the executive and not to the courts. In other words, the members of the Administrative Tribunal are not necessarily judges, although there are members of the federal court are there, but they are essentially part of the executive and not part of the judiciary. And what it essentially means is that if there is a government decision, Commonwealth government decision, such as a decision made, for example, by the Australian Taxation Office, or a decision made by Centrelink, or a decision made by the Child Support Agency, the decisions, the administrative or executive decisions of these agencies can be appealed to the Administrative Appeals Tribunal. But in that case, you begin to wonder, when the Administrative Appeals Tribunal reviews these decisions, isn't the Administrative Appeals Tribunal exercising a judicial power? Or is that what is known as a quasi-judicial power? So we're not going to go deeper into this at this stage, because questions about the role of the Administrative Appeals Tribunal is actually examined in greater detail in the unit on administrative law. But suffice it to say that although in a sense there's almost like quasi-judicial powers that are being, they're not judicial powers in the sense that they don't really involve matters, but actually just involve a review of decisions of the executive. So it's not about the Administrative Appeals Tribunal having making decisions about a matter between private citizens. It's not, because that would involve the exercise of judicial power or a matter. But here, when we talk about the exercise of the review powers of the AAT, it's really only in relation to a review of administrative or executive decisions. The other aspect of scope of executive powers is really the power to, in a sense, of the executive, in a sense, to pass laws. And these laws are in the form of regulations. So it could be regulations about taxes. It could be regulations about fair trading. It could be regulations about the workplace, for the Fair Work Commission, and so on. And when there are policies and regulations that are being drafted and crafted and issued by these executive government agencies, we can see clearly that the scope of executive powers goes beyond just executing current laws, but also in the form of, in a sense, passing laws. And because these are known as, these are in fact laws that individuals must or corporations must comply with. So in a sense, these are the exercise of legislative powers, but they are in a sense quasi-legislative, because oftentimes the crafting of these regulations or policies are really based on a statutory grant. So there is a grant of power issued by the Commonwealth Parliament to a particular administrative body, which allows it to pass certain regulations. So in a sense, they're quasi-legislative. And in regard to quasi-legislative powers, or the power to pass what is known as subordinate legislation, the High Court, as we will see in succeeding weeks, has been very clear that it is permissible for these quasi-legislative powers to be wielded by the executive. And so, after studying this topic, you should be able to discuss and explain the concept of responsible government, the concept of collective responsibility, the concept of individual ministerial responsibility, and provide an overview of Commonwealth executive powers. And so with that, I thank you for watching this recording and have a great day. Thank you. Bye.